We're back on the record.
Back on the record. Mr. Sure, your next witness, or did you have something you wanted to address?
Something to address.
Yes, go ahead.
The next witness, I believe, would be Michael Balin.
Yep.
And I was going to use an exhibit that's designated confidential in some of the questions for Mr. Balin. So you may have to make those accommodations with respect.
Okay, so then, yeah, we'll do what we did yesterday in terms of, well, let's do whatever we're gonna do and until you ask your questions, but I appreciate the heads up. So everybody's prepared to do what we need to do. Michelle, over here. Okay. Mr. Sure, you want to proceed?
Our next witness is Michael Bailey.
Okay. What is his proffered testimony exhibit?
Exhibit 40.
Okay.
Good.
Yes, you can swear the witness.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got?
Yes, ma'am, I do.
If you would state your name and spell your last name for the record.
Michael Balin, Bailin.
Well, Mr. Balin, may I direct you to exhibit 40 in the green binder in front of you, please? You recognize that document?
Yes, sir.
Is that your written testimony in this matter?
Yes, sir.
Ask the witness until redirect.
Yes, sir. Ms. Cribs, Mr. Iorio?
Some questions.
Morning, Mr. Balin.
Or, sir.
I'm Robert Iorio, representing Captain in this proceeding. I met you at your deposition.
Yes, sir.
Want to start off, do you have your written testimony exhibit 40
Yes,
open?
sir.
So you indicate in paragraph 2 that you're the general manager of taxi management.
Yes, sir.
How long have you held that position?
I've been the general manager for, next month will be 5 years. Prior to that, we had a little bit different business model where we used an executive committee in lieu of a general manager or CEO. And I was part of that executive committee. I don't remember exactly how many years it was, but it was a number of years as well.
In total, how long have you been employed by taxi management?
September 10th was 27 years.
During those 27 years, what software provider has taxi management used for its operations in Park County?
Prior to using Captain, which we're presently using right now, we use a system called Aleph.
Spell?
I believe it was ALEPH. It was more of a limo software system. We just had a lot of homemade products that we used on the side.
Okay.
Built on.
And if you can tell me approximately what year did taxi management switch to Captain technology?
I believe it was 2015.
Were you involved in the decision to switch to Captain?
The board of directors made the final decision, but I was part of providing them information.
Did you provide a recommendation to the taxi management board?
I believe I did, yes. It was a long time ago. I don't
Understand.
recall, but I believe I did.
And generally speaking, what do you recall recommending to the board about Captain?
I thought it was an improvement from what.
Did that turn out to be the case?
Yes, sir.
And that was 2015. And in terms of your position, so that's 5 years as general manager and 5 years as a member of that committee?
I don't remember if it was exactly 5 years as executive committee, but it was 3, 4, maybe 5. I don't really recall. It was.
Fair enough. During the 10 years that taxi management has used Captain technology, how would you describe your day-to-day involvement with the software that's provided by Captain?
I use it all day long.
And as a result of using it all day long, do you feel that you have a good position to assess technology in terms of its value to taxi management?
Are you asking me if I understand how, if you show me how to use a program, I can use it, but how it actually works in the background, I'm not the right guy.
Oh, it was a different question. In terms of how the software works for taxi management, do you feel you're in a good position to answer questions about how the technology may have benefited taxi management?
I'll do my best.
Okay. So, in generally speaking, over the 10 years, from your positions, have you been satisfied with the technology that Captain has provided?
Satisfied, I would say I have been satisfied. There are a lot of bugs that we've had to build a lot of workarounds. We have, we've had tickets in for years that never got resolved. And so we've had to kind of build some workarounds. Like Captain, I think Chris is a brilliant guy. I think his support's not there. There's just a lot of bugs.
And Chris, you're referring to Mr. Bordenaro?
Yes, sir, I'm sorry.
No problem. Right. Have you been, what, in terms of new developments, improvements, and enhancements, have there been specific requests, taxi management, to Captain with respect to functionality that you would like to see in the software?
Yes,
And in your view, has Captain been responsive to requests that you've made over the years?
on some of those projects, yes.
What any in particular come to mind?
Well, recently, Chris Bodnaro just helped us with integration from the cab surveillance system we use, which is called Nado. And is helping us, or he just, actually, I think he's completed it, where the names are automatically coming through where we don't have to somebody, it's an AI system. So he's helped with that. Recently did work with the Lost and Found program. So yes, sir.
Okay. And have you been involved in the contract renewal process over the 10 years that Captain has provided technology?
Yes, sir.
And now, Mr. Vice Chair, I would get to the confidential agreement.
Okay, so we need to put everything on mute. Let's verify that it's on.
But you probably should do something. Yeah, they're on silent.
Okay, I think everybody's back in. We're back on the record.
Yes.
But Mr. Sure, do you have any other witnesses? No other witnesses. Okay. So does the authority have any witnesses?
So we would like to submit Mr. Park's written testimony and his deposition to the record, and we don't think it's necessary to call him as a witness unless the board has specific questions for him and other folks have questions.
Okay, well, let's go to the other folks first. So does anybody, and we'll go around the room, have any questions that they want to address to the administrator? Or are they going to rely upon his deposition testimony and his written testimony?
On behalf of the applicant, we're going to rely on the deposition and the written and our right to comment on during closing briefs.
Okay, Mr. Yorio,
Captain's position is the same.
Mr. Talmadge,
Same for IPSC.
Mr. Sure,
The same for my clients.
and you don't have any questions? No, I was looking at Miss Guerra, sorry.
I have no further questions for him.
Member Decker, do you have any questions of the administrator?
I do not.
I do not. I want just an affirmation from council that his testimony has not changed given any of the information that we've received during this hearing.
There's one minor change from his written testimony.
Then he needs to get in the chair and we'll swear him in and we'll ask him the question. But that's do what I gotta do. Please swear the witness.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
And Mr. Todd, can you please go into the brief and exhibits binder, which has got a green label on it, and we'll turn to page 41 or exhibit 41. For the record, can you please tell us what you have in front of you?
It is my pre-filed direct testimony.
And have you had an opportunity to review this exhibit?
Yeah.
Is there any changes that you would like to make to this exhibit?
The only change is it asked what my position was at the time that I gave this. I was the administrator for the Taxi Cab Authority. That is still true. Still the administrator of the Taxi Cab Authority, but I am also the deputy commissioner for the Nevada Transportation Authority.
Okay, so how do you think that changes your testimony?
Does not.
Okay. And council, are we okay with, it doesn't change any substantive statement? It just
Doesn't seem to change any substantive statement. However, it is, it's a factual update.
He wants to update it.
Yeah.
Okay, so does any council have any questions regarding that qualification?
None for Cap.
None.
Mr. Decker, do you have any questions? No. Okay. And just to make clear for purposes of the record, you've done this a couple of different times on the record in various meetings. You don't have any policy making decision authority in your position with the Transportation Authority. Is that correct?
That's correct.
Okay. Nothing else. Unless somebody has any question on that. Okay, then I'm going to release the administrator.
Thank you.
Thank you. Okay, so I think we're at, and I'm going to give you a chance here, Mr. Tomlinson. I think I know where you're going, right? So we're at the opportunity of exhibits are admitted, depositions are admitted. Is there anybody that wants to submit any additional documents or testimony at this time?
Neil Tomlinson on behalf of IBSC IP.
Yes.
Yesterday, I made reference to a request for judicial notice of some meeting minutes. And I'd like to identify two of those. These are Taxi Cab Authority Board meeting minutes. The first is from December 15th, 2014. And the second is from January 29th, 2015.
Can you please restate?
December 15th, 2014. And January 29th, 2015. And I wanted to confirm that all the deposition
Hold on,
transcripts.
let me make sure of something here real quick. Does anybody have any objection to the submittal of those meeting minutes as supplemental exhibits?
On behalf of applicant, no.
Mr. Sure.
I don't have any objection to the authority taking additional notice of official meeting to the next. Are actually relevant. Not reviewing them, I don't know. I don't know that they need to be made part of the record.
No, that's what I was gonna do after we got through and if there was any objection. So what I'm gonna do is I'm gonna say that those two meeting exhibits, we're gonna have them as next in line. I think that's 48, 49. Don't we have 46 and 47 from?
Oh.
Mr. Vice Chair, I had a question. I wasn't sure that all the deposition.
Okay, so those,
It'd be 55, 56, right?
All the depositions.
Oh, the depots, was-
because we did all the depositions as exhibits.
yeah. Yes, that sounds right. We added the depots as exhibits, right?
But what they're saying is they did them by number. Okay, so let's go through and do that real quick, just so we have a clear record here. So we had 46 and 47 yesterday.
We had 46, 47 before, which were depositions with Balaban and depositions with Myers. Then there was a motion to admit all of the depositions. Yep,
It'll be 55.
that's the objection.
Okay, so let's do this. So we're at 40.
We're at 47, but that's.
And 48.
We're at 45 before we got to deposition.
So 46 and 47. So 48 is going to be Bordenaro. Oh, here we go. Somebody already did it. The 48 is going to be Bordenaro. 49 is going to be Balin. 50 is going to be Bell. 51 is going to be Massell. 52 is going to be Schwartz. 53 is going to be Mr. George. 54 is going to be Mr. Park. Who's 55 and 56? Okay, the minutes 55 will be December 15th, 2014, and
January.
either Matt or Lona, can you insert those and then circulate them to everybody, the parties? And then 56 will be January 29th, 2015 meeting minutes, and they'll be circulated to everybody. Does anybody have an objection to adding those as a? Okay,
Again, I don't know the need to add, if it's certainly be circulated, so we will receive copies of them, because I don't think Mr. Tomlinson has copies of them with him today.
no, so we will circulate them as exhibits 55 and 56, right? Did I say the numbers right? All right. And that will become part of our record for purposes of this hearing. And that, so that Mr. Reeser will also have the benefit of those documents to review, and we'll have the ability to review them before making our decision.
With regard to, and I made reference in cross-examination yesterday to some minutes of legislative hearings. Those are online, they're publicly available. I'm feeling that that's legal research. I don't know whether I need to submit those as exhibits or whether they.
I think those fall in line with treatises and that sort of thing. I don't think we need to admit them as exhibits. I would, if I was you, I would reference them in your closing brief and potentially attach those as exhibits to that so we can review them. I think we can take that into consideration as a basis for the legal foundation of our decision. Anybody else have any other documents? Yes, Ms. Guerra.
I've had an opportunity to respond. I don't necessarily object to Mr. Tomlinson's request. I would add that if we are going to incorporate the authorities, basically the authorities meeting minutes and meeting record in his exhibits, I also would like to add the meeting minutes of February 19th of 2025. And there is a recording of that meeting that's currently on YouTube. I would like to submit that as well.
Okay, and what's the basis?
That is the initial meeting where this matter was discussed and where the board laid out what they would like to see from the parties as presented in these proceedings.
Any objection to that?
No objection.
Mr. Yorio?
No objections. Don't know why it has to be an exhibit. You have orders that have been issued.
Well, then sounds like you have an objection. Okay.
Because it's I should explain, it's incomplete to have those hearing minutes without the orders after hearing.
And I tend to agree, but let me listen to everybody else and see what they say. Mr. Tomlinson,
I don't necessarily have.
Mr. Scherer,
I have no objection. I would say that the orders are obviously part of the pleadings in this matter. And the minutes may reflect what was intended in the orders and I think should be at least fair game for argument in the groups.
sure. So, and that's what I would say. I would say this. I would say that, no, we're not going to admit it as an exhibit. I think the board under 233B has the ability to look at the whole proceeding. That's part of the proceeding. It was agendized and discussed. And so we have the ability to go back and look at our minutes. The reason why I admitted as exhibits the prior meeting minutes was because none of us were on that board at the time. And I think that it's informative and that we would need it. It was obviously offered by one of the interveners. So I want to make sure that that information that's in there, we have the opportunity to review it. I think for February, I think that we were on the board at the time and we can independently go back and take a look at that and you can certainly reference it in your brief, Ms. Guerra. Okay?
Thank
All
you.
right. Yeah, not a problem.
I want to comment on just minutes again, I assume. Without having reviewed them, I don't know whether I think they're relevant or not. So I assume I get to argue that.
There's going to be no limitation. We're going to talk about the closing argument briefs here next. Does anybody have any other documents that they want to proffer to be part of the record for our consideration of this rate increase?
I do have a handful of short rebuttal questions I'd like to pose.
Mr. Myers, oh, he is. Well, is there any objection to calling Mr. Meyer?
Yes.
What's the objection?
The procedure in the regulation allows for rebuttal by the applicant, not by. We're going to allow rebuttal by interveners. We would perhaps want to offer
Okay, what's your response, Mr. Yorio?
Well, if taxi management intervener has questions on the subject I'm going to speak to Mr. Myers about, he can cross-examine.
Okay,
If that's the concern, I don't object to that.
so Mr. Feely, what do you feel on this? The procedure. Do they have the ability to call a rebuttal witness as an intervener or does only the applicant?
So I'd have to check the specific statutes on for this authority. As
So
far
it
as
should be 233B, like, I think it's like 330 or something.
it's in NAC 706.
would be some 233B wise, or even open meeting law wise, I would have no objection to it. However, if there are certain procedures laid out within the,
What's the
Taxi
NAC
authority.
you're referring us to, Mr. Scherer? No, I've got 706, but it's about an inch thick, so.
Yeah, I'm trying to find it.
Mr. Vice Chairman, may I propose a short recess while we look for the statute?
Nope, because I want to, if we're going to clear this up, we're going to call the witness before noon. We're coming up on the noon hour. And I want to make sure that one way or another, we have a resolution of the issue before we either break or don't break.
Understood.
Like if we're going to call rebuttal witnesses, we're going to take a normal lunch. If we're not, we're going to take 5-10 minutes. Just clarity.
NAC 706.945. two. Evidence will be received.
Hold on, let me get there. Let us get there. Hold on. 945, you said?
Yes, NAC 706.945.
Does,
I didn't hear Mr. Sure.
it's at subpart 3.
So part 3 does allow.
So just for purposes of record, we're reviewing NAC 706-945, presentation of the evidence. Subpart 2 is what Mr. Scher is referring to. It says evidence will ordinarily be received in the following order. Upon applications, which I think is what we're talking about here today. And then it says number 1, applicant, authority staff, interveners, and rebuttal by applicant. I think we've generally gone in that order of presentation of proof. We're at the point where I'm asking other additional parties. In this instance, an intervener is requested to submit additional information. And that says its evidence will ordinarily be received in the following order. I think that unfortunately, I want to err on the side of getting in everything as opposed to not getting in everything. I think that Ms. Bremserick could, and she's looking like she's going to stand up and I'm assuming say something that I think will solve this problem. What is it?
Sure. So I think the key word is ordinarily. I think the board has discretion to do what I think Mr. Chairman's considering doing. But to resolve this, I can call Mr. Myers and then pass the witness to my colleague.
Sub 3. And that was my thought.
Subsection 3.
Sub 3 specifically. Yes. It says the procedure described in subject may be modified at the discretion of the authority's presiding officer. I think there's 3 different workarounds to this, Mr. Scher. So what I'm going to do is I'm going to allow the testimony. If you want Ms. Bremserick to start the questioning, we'll have her start the questioning. But in sake of time, I would hope that you would just allow Mr. Yorio to ask his question.
You're going to exercise your discretion, but I will just
I would.
for the record.
I get it.
Lodge my objection that if that had been the procedure outlined at the beginning, we may have decided to have other witnesses available today.
Well, that I will not say because you have the opportunity to present evidence. You've got the rules in front of you. You know how it should have gone. So if you had witnesses, you should have had them here today. So I'm not going to say that. I'm not going to let that just float out in the air because that's something that a judge may look at a later day. If somebody does a petition for judicial review and say, hey, you didn't allow this. I allowed it. If you've got a witness, call them now. So that's my point. And so they want to call Mr. Myers. I'll let them call Mr. Myers. I'm not going to foreclose at the end of this that if he says something you think you need to call another witness, then call another witness because we're going to err on the side of getting it all out there.
Mr. Chair, at this time, I would like to call Andrew Myers and I will delegate my rebuttal on behalf of the applicant to my colleague, Robert Yorio.
That's fine. Shelley, you got to swear him in again.
You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Thank you. Mr. Myers. There were some questions that were asked of you from Mr. Decker right at the end of your testimony the other day. And they involve the subject of possible insurance coverage with respect to IVSC's claims of patent infringement. Is that an issue that on behalf of Captain you looked into?
It was one, yes, it was one of the proactive solutions we looked into right away.
Can you tell us what you did?
Objection, it's not a rebuttal, this is recross. You have the opportunity, Mr. Decorate, to answer the questions. Recross examining with regard to these points.
And what's your response, Mr. Yorio?
Well, I thought we broke for the day at the end of that. But this is to clarify the situation of insurance coverage that I think, my point of view, I think was a little bit unclear from the record.
Okay, I'm going to overrule the objection. I'm going to limit it to those questions in that
Right.
area.
I also want to be clear that part of the catalyst of understanding that our insurance carrier was to be reached out to was actually delivered in one of those industry meetings by another operator,
And who is that?
Bill George.
Now, with respect to Captain's situation for insurance, is that something that you looked into?
Yes.
And what did you do?
Reached out to our insurance broker and provider right away and asked them specifically if this fit into any classification of coverage either that we currently hold or that could be quoted and insured.
What
you
did-
say that- did you say a name for your insurance company?
I said our broker,
What response did you get?
that this type of infringement assessment or coverage was not part of a policy that they could put onto the company.
And did you ask counsel to look into this situation of possible coverage?
Yes, I did right after that communication was delivered to me from the broker. And then I also asked counsel in other cases and in experience of patent infringement cases, are you familiar with coverages like this being applicable?
And did you ask, and what responses did you receive?
Normally and conventionally, these coverages are not applied to companies like this.
And did you have counsel look specifically at Captain's comprehensive general liability CGL policy?
Yes, I did.
And who did you ask to do that?
I'm going to object. They've asserted attorney-client privilege all throughout this proceeding. And now at the end of it, they want to waive attorney-client privilege.
That appears what they've done, so you can ask questions about it.
Can answer.
Counsel that I appointed to look into.
So wait, just overruled. My reason being is I would agree with you as to this topic at least. Go ahead, you can answer.
The counsel that I appointed to look into the potential opportunity to have a GLI for patent infringement protection was you, Robert Urio Carnival.
And what did you learn about whether CGL policy of Captain had an exclusion for patent infringement claims?
Yeah, I learned that it could not insure ourselves against patent infringement.
And because of the information you've learned from the broker and counsel, is that a reason, did that affect your decision not to make a tender to the Captain carrier with respect to IDSC's assertions of patent infringement?
Yes, it did.
Objection leading.
I think it is, but I think we're at that point where I'm going to overrule that.
Nothing further.
Thank you. So his terms are passed on the witness. Mr. Tomlinson, Mr. Sure.
Mr. Myers, how did you communicate with your counsel with regard to the questions about insurance? insurance coverage for patent infringement?
First, I invited Mr. Urio to the industry meeting, which multiple operators, including specifically Mr. Schwartz and Mr. George, were present. And when Mr. George stated what he stated in that forum, Mr. Urio and I spoke directly after that meeting. And at that point, I tasked the policy binder to Mr. Urio to look at it first. I also reached out to Harris Beach as well in conjunction with Mr. Urio to get a second opinion on counsel for this. And Mr. Urio and the broker both came back to me and said that this was not an applicable opportunity for us to get coverage on.
How did you reach out to the broker?
It was either a phone call or an email. Probably a phone call. The broker's a local friend of mine. We have all of our policies through him. He's a local Las Vegas guy.
And who is that?
It's Levitt Insurance, Mr. Scott Hoffman.
And how did you reach out to Harris Beach?
I don't specifically recall. Harris Beach was invited to both of the industry meetings. I believe they attended the second meeting, and the two attorneys that could possibly have been in attendance, one or both, would have been Ian Kinnett or Neil Slifkin.
And did they give you their view right there that day?
No, it took some days for them to digest the information and the situation and come back.
And how did they come back to you?
It was either email or call. I don't specifically remember which one.
And did you provide the insurance policies or any of the emails you received? Did you produce any of those in this proceeding in response to the request for production of documents?
Oh, well,
Thank you.
Ms. Garrett?
Good morning, Mr. Myers. Still got 2 minutes before the afternoon. So I'm a little confused. So if I ask certain things that you already stated, please forgive me. I just want to make sure I understand everything. So when you had a discussion with your insurance, did you actually file a claim with your insurance, or did you ask them whether or not your policy would cover patent infringement?
yeah, we specifically asked the specificity around the patent infringement case.
Did you file a formal claim with your insurance, or just did that general phone call like, hey, does my policy cover this?
That was the start of it with some more specificity from counsel, and then they went back and checked internally and came back and said, this is not able to be covered.
Are
So
you,
I would consider that not classified as filing a claim, assessing if a claim was able to be filed.
understood. Do you know if your insurance broker or whoever provides your coverage did an independent investigation of your request?
I'm not sure the detail of how deep they went into into assessment.
Okay, so
Provided them initial information that they asked about the patent infringement assessment.
understood. So just to clarify, they didn't give you like a report or any type of breakdown, like, hey, this is why we're denying this, or hey, this is why we can't cover
Yeah, I
this.
wouldn't consider what was the information delivered back as a yes or no was formal, packeted binder type of response, in
Understood.
which like you would see in a claim analysis or a binded package from an insurance provider package.
Understood. No further questions. Thank you.
Follow up, Ms. Cruiser? Mr. Uriel?
Nothing further for comment.
Mr. Tomlinson?
Yes.
Mr. Sure? Member
One,
Decker?
one question. Mr. Myers, welcome back. During this period of time when you were exploring options, reaching out to the insurance company as you testified to, do you remember yesterday, Mr. Bolsonaro testified that he was asked if he based his software development on any existing or proprietary pre-existing technology, and his answer was no. Did you have any conversations with him in which he expressed that to you?
No.
All right, thank you.
That's it.
Just two little areas. So your submittal to Harris Beach and your broker, that was after the meetings that were held in October and December of 2024.
Correct.
You didn't do that in 2021.
No, we did not.
Okay. So did you ever get a reservation of rights letter from any of your carriers?
I would have to double check on that. I'm not totally sure.
I'm
We
assuming,
do have a department internally that manages most of that for me. I could go to them and inquire on that.
okay, I'm assuming you didn't, because you didn't file a form of claim with your
Yeah,
carrier,
correct.
right? So that also goes to, you didn't get a denial from some carrier, right?
No.
Okay. That's all I had. Does anybody have any follow-up regarding those questions? This,
Nothing further.
sure.
No.
Scara?
One question, and I apologize. Did you also make a request to see if you would get coverage for indemnification purposes?
I would have to double check on the specificity of what I asked outside of the scope of informing them about the patent assessment and claims analysis that had been performed by counsel. I don't know if that extra language was included. I would have to double check that.
Understood. Thank you. No further questions.
Anybody on those questions?
Nothing further.
And I don't have any follow-up regarding those. Okay. Your release. Okay, going back to where we were a few minutes ago. Anybody have any other documents or any other testimony they want to present?
Nothing for
Nothing.
Nothing for us. Thank you.
Okay, so we're gonna have the matter closed as to the presentation of evidence and testimony. We have all the evidence in form of the exhibits, the depositions, the other things that we've admitted today, and all of the testimony over the last 3 days. What's going to happen is there's going to be a record that's going to be produced by the court reporter, transcript, and we've been assured that it'll be prepared in about 10 business days. Our desire and goal is to put this on, and I think Alona's going to put this on for the October 15th hearing. So we're going to agendize it for consideration and decision by the board. Right now, I envision that it'll be myself, Vice Chair Graff, Member Decker, and Chairman Reeser that participate in that process. However, under statute that we cited to yesterday, 233B 124.
It sounds right.
At that point in time, does anybody have any objection if Member Weekly and Member Vasquez want to participate? Because they're going to be able to read the whole record. We're allowing Member or Chairman Reeser to do that. So the option is out there. If there's an objection, I want to hear it now so that we address it going forward.
Vice Chair Neil Tomlinson, I'm at IBSC. That's the question that I would have to pose my client. I cannot say right now whether I.
So let's,
agree or not.
well, okay, we'll handle it another way. And I see other people wanting to stand up. So here's the issue that I want you to address in your closing briefs. Okay, so we're going to work backward from October 15th. Right now, it'll be Chairman Reeser, myself, and Member Decker that will consider and adjudicate the application, the petition for rate increase, unless there is some consensus to allow Member Weekly and Member Vasquez to participate at after reading the record pursuant to 233B 124. I want you to address that in your briefs, and I want to work backwards from that, by the way. So October 15th is the date of the hearing. So I think we need your briefs at least 10 days before that. So that's going to be October 5th. And is that a Monday or is that?
Sunday.
So we need to do October 6th, we'll say. Okay. So briefs will be due October 6th.
I'm sorry. So I'm, for the record, Jessica Guerra, on behalf of the administrator, I'm looking at the calendar now. If it's 10 business days to produce the transcript, then based on my calculations, it's going to be available October 3rd. And so having a closing brief by October 6th, if folks want to refer to the transcript, it may be difficult to do that considering there's a 3-day turnaround.
So you have the opportunity to discuss collectively an expedited transcript. The decision, or at least there was a discussion as to procedure that was had, and it was my understanding the parties had decided not to expedite the transcript. So do the parties want to expedite the transcript?
I think we should have another discussion. We're going to have an October 6th briefing.
I can always move that deadline, but we need, as the board and, myself, we have a day job. So we want to have the ability to review, at least a couple of days, at least a couple of business days. I'm willing to shorten that up in terms of our review. So what's a week before October 15th? So October 8th. So maybe that's the date we have the briefs due is October 8th. You guys can still talk to Michelle, our core reporter. And if you want to expedite the transcript, you can expedite the transcript. She's been doing roughs daily, so who knows if it's even going to take 10 days. Okay, October 8th is the date for briefs. We've already discussed that format. It's going to be 30 pages under the local rules, not under the appellate rules. Yes.
DA office.
Yes. Oh, yeah. All briefs, as everything that you've submitted in this case, filed at the TA's office by end of business on October 8th. Thank you. Yes.
One question, do you want duplication of exhibits or just reference to the exhibit package that we already have?
That's a good question. I think that we already have these exhibits, so you can just reference them. Everybody's got a good exhibit book, right? I mean, in terms of everything that we're talking about. All right. So I just ask that the authority supplement our exhibit books to include I know we have the depositions, but if we can change those to the numbers to correlate to the numbers that we did today on the record, and then add the meeting minutes that we discussed to our books.
At the next hearing, are the briefs the end of it, or is the hearing anticipating some sort of also closing argument?
No, what's going to happen is, and that's a good question. Thanks, man. So it's going to be agendized for our decision and discussion. So obviously you're going to have the ability to make a presentation. What I envision is that this will be the last item on the agenda. And if it takes a while, it takes a while. So at least the 3 people that you know of on the board, we're going to have read the briefs, and we may even have kind of like Chairman Reeser ideas as to issues he wants addressed, and he may ask you to do that. But we're going to agendize it. You're going to have the opportunity to discuss it during that process, because it's open meeting and you're going to have the ability to get up and talk. So thank you. Yes, sir.
Yeah, we've got to prepare a brief and prepare a closing argument. We're driving up the cost for our clients.
I cannot change the open meeting laws. So you guys, the parties, it's my understanding, wanted to do closing briefs. That's fine. I have no problem with that. And I appreciate it, because then it gives us the opportunity to focus our arguments and questions on you guys at the time of closing. There's no requirement that you do a closing brief. You can just come and appear pursuant to the open meeting law and the agendized item. And you can also, under those rules, check me if I'm wrong, Mr. Feely, but under the open meeting law and under our rules for the tax cap authority, you can file things just to be presented to the board under an agenda item after the agenda has been produced. So I would prefer to do it this way in a structured fashion. I get it, that it's going to cost whatever, but we've already got 3 days in the can already on this thing. So let's make sure that we have everybody's arguments in writing, create a clear record. So if somebody's going to file a PJR, that they have writings to reference. That would be my preference.
Right on, I have different issues, so go ahead.
So I have two questions then. And then because it's been brought up as a PJR, there are certain things that I would like to get on record just for clarification. But first question is the closing brief now optional where the parties can receive the transcripts and submit closing arguments on October 15th? Or are the closing briefs going to be required with the still opportunity of being presented rebuttal arguments on October 15th? Or is it going to be, we submit closing briefs on October 8th with questions from the board being presented on October 15th?
That's covered by the NAC. So if you look at NAC 706-963, subpart 2, the authority or the administrator may in their direct discretion following the filing of the briefs or upon contested motions, set the matter for oral argument, 10 days notice must be given to all the parties of record unless the authority or administrator deems a shorter time is advisable. So we've had the hearing, everybody submitted everything, we've submitted evidence and testimony. I'm saying that you have the ability, if you want, to submit a closing brief on or before October 8th. Don't have to. You can show up and make closing arguments. We're going to agendize it pursuant to the open meeting law. Does that answer your question? May not be the answer you wanted, but it's the answer I'm giving.
I believe it's understood. Thank you.
Anything else?
Different issue, and I mentioned this earlier, but I do have another hearing that morning, so I believe you said this will be at the end of the agenda, which I assume would be in the afternoon.
It will. So just if you would, call and remind the other parties as to that. Nobody's going to try and sandbag you or anything else like that. We'll make sure that you're here when we start that portion of the hearing. Okay? All right. If you think that, by the way, if you think that it's going to run much longer or something like that, then tell us, because we can always do a special meeting. We didn't want to do a special meeting. Okay.
I haven't seen the agenda yet.
Okay. All right. Well, feel free. You can always address it. We can always, handle it accordingly. Yep. Anything else? Okay, so we're in an open meeting still regarding this. It's continued from the last couple of days. So I'm going to open this up for our public comment. If anybody has any public comment here in the room.
I just had something completely unrelated to what we've been doing for the last 3 days. As an
If you'd
aside,
approach the podium just to make sure we get you under a mic.
now this is just more of a quick acknowledgement. I serve on a board for the Imagine Dragons. It's the Tyler Robinson Foundation. Bad name right now, but it's been around for a dozen years. And I learned that Captain had donated all of the transportation for our cancer families this past weekend. So I just wanted to acknowledge that silent philanthropy. I think it was very important and meaningful. Thank you.
Anybody else have any public comments here in the room?
It's I'll submit it under public comment, but it was related to the prior agendized item. I just want to make for the record that under NAC 706.945, and then just to be prepared for a PJR in the event that it is filed, the administrator also has specific authorities under subsection 3. He has not opted to exercise those authorities.
Understood. So that was not in public comment. You were making that in response to our previous proceeding. So I'll reopen it as to public. I understand what you're saying. Reopen for public comment. Anybody online, Madam Secretary? Okay. I'll entertain a motion.
So moved. No quorum, we can't adjourn. We can't adjourn. I'm stuck here.
We're going to adjourn. So that is kind of funny.
Yeah.
I was like, that's what I was thinking. I was like,
We were never really in session.